Krasinski never comes up. He, as he said he would, he ignored it. It didn't count. That's what took place. To say that, that's like saying hey, you can play a baseball game, and if you win, we'll say you won. But all the runs that you score, they don't count. And besides that, of course, because of this court's particular rules, I got to pay for them, for the 6 days of evidentiary hearings that don't count. Due to this court's peculiar rules, I have to pay the referee for his time. I have to pay OLOR for their time. And for why this matter took so long, Justice Crooks, two things should be pointed out. First, there was an appeal. Remember that, Judge? We were here before because there was an appeal granted to OLOR, an appeal that was worthless, lasted for a year or so, cost me thousands of dollars. Now I got to pay for their time when this court's ruling was rendered worthless by the referee's actions. And in addition to deposing these people, the depositions, I was shut down from deposing people up until spring of 2008. That's right, spring of 2008. I had to fight tooth and nail to be able to depose people. During the process, OLOR was caught repeatedly making falsified assertions in order to cut off the depositions. They repeat, one of them being that they had investigated whether or not Justice Crooks' son's client, Kranz, had committed perjury. They said that they had investigated that. He had been cleared. Then they turned around and had to admit under oath that wasn't true. Okay, but they put that out to kill off the depositions.
Counsel, maybe careful what I ask for, I might get it, and that is with regard to context. You know, I think that context is important, but the things that you're relating now, I've got to narrow down to what's the issue before the court. The issue before the court, in part, is, was there a violation in count 2?
And I would say no if you see it as the elements. You want to say I was disrespectful on that day, go ahead. As I've said since the very beginning, go ahead and say it. I'm not going to argue it. You want to say that I made a statement and knowingly, with reckless disregard of the truth, and that is the rub, because the whole thing is to discredit me on what I was saying in court. No, everything I said that day was true, and I've proven it over and over and over.
Okay, with regard to count 3.
First of all, in regards to count 3, none of the statements that she has said today is very misleading. In regards to, I didn't violate any order. In fact, I think in her brief she says there was some sequestration order. No, never took place. 2, I never controlled any website. Now, did I participate with the website? Yeah. I didn't publish anything. I didn't control anything. 3, in regard to this whole thing with the jurors, it's amazing that this is even being said. It shows, in all due respect, that something is way off the tracks. Her boss, under oath, said I had been cleared, that it never should have been included in the complaint. It was never even presented to the PRC, and that I had been cleared, that I had nothing to do with it. Then how then can it be resurrected at a hearing where I'm not even present, and now to be considered against me? I don't think that's just. And again, Your Honor, I guess to wrap it all up, I see that the red light. Here's what I think should be done. Number 1, in count 2. You want to say I was disrespectful? Go ahead. But you owe it to me, because you owe it to the cause of justice and to the citizens of this state, to acknowledge that what I said in court that day was in good faith. In regards to count 3, everything I did on that day was authorized by the Supreme Court rules, and incidentally authorized by Judge Bukowski on May 24th. I think it's about somewhere in the page 50s. He said, you can take your claims public. He said it in court. And so, for what I did on that day, everything I did was in good faith. And it should also, again, be seen that what I did, I was trying to alert the public to something that was truly, gravely evil. It was immoral, it was evil. And the public needed to be aware. And to act like you can do something on appeal when you convict a young teenage boy through a fraudulent case, like somehow, well, we can fix it a few years later. As this court knows, as judge, as everybody here knows, appeals take a long time. I guess if he rotted in prison for a couple of years, well, we can all say then maybe he could have maybe then he could put his life together. It'd be a good learning, education experience. I didn't see it that way. So everything I did in count 3, I say, was justified. And in the end,
Counselor, did you anticipate that any of the prospective jurors would hear what you had to say or read what you had said in regard to the trial?
Your Honor, that's why I did it exactly the way that I did it. And that's why no jurors did. When they were voir dired, Your Honor, that proves that I did it the way that in a very responsible way. That's why not a single juror was aware of it.
Okay, so
I never intended to get it out to the general
public. So the answer to my question is no. You didn't do it to provide this information to a potential juror.
No, I did it to provide it in the public. The public is a big thing.
Now, I understand.
Right.
I just want you to answer my question.
Right. Okay. And there were segments of the public that I thought, who the responsible, basically, segments of the public, I wanted to become aware of it. And I did it carefully in that way. And again, it cannot be overlooked. Somebody planted, in this case, a falsified story that could have sent the boy down. That was the thing that was the most troubling of all. And for some reason, even to this day, nobody cares to find out who fed that falsified story to Channel 27.
Well, they probably won't tell. They generally protect their sources, so you're probably out of
That's
luck.
probably true, and that's why in the DA's office would have probably known that. But the bottom line is, somebody did. We know it's a fact. And the third thing I'd just like to say before I go is, I think one of the mitigating factors, she said selfish motive or something like that. Well, you know what? I must really be a fool, and I think the justice has sort of conceded I'm not a dumb guy. I would really have to be the dumbest guy in the whole world if that due to some kind of selfish motive, I would set everything up where I would financially ruin my family, destroy my profession, destroy my reputation, and if this is what my motive was. I don't think there's a single one of you that can believe that for one moment. And if that's not a mitigating factor, I don't know what is in the considerations of what is just.
Thank you, Mr. Sommers, and thank you, Ms. Scott, for your arguments and your responses to the court's questions and your various filings in this case. Court will take this under advisement, and as I say in every judicial and lawyer discipline case, these are always the hardest that the court has to face. And so ends our hearing in 06 AP 2851D, Office of Lawyer Regulation versus Joseph Sommers. That ends our November calendar, and the court will meet in the conference room at 3:30. That's 20 minutes instead of our usual 30. The Marinette students, can you stay to talk with Justice Crooks, or must you leave? Somebody should talk with me. Pardon me? You're on for a short time. All right, good. Anyone else who wishes to leave may do so. Anyone who wishes to stay and listen to the conversation about the procedure of the court may stay. The court is adjourned for the November sitting.